So today we have law of contract. We're starting with law of contract, and we would be sorry, I'm trying to bring up my marker. We will be looking at the introduction to law of contract. What is contract? We have heard about this thing so many times. Contract this, contract that. We entered into a contract with somebody and to deliver something, and the person did not deliver. What am I supposed to do, Oga lawyer? See, in order for you to know what contract is, as it relates to law, you must first know that it is not every agreement that you have with somebody that it's called contract. There are contracts and there are mere agreements. When we look at the definition of contract, you would see that contract has elements. And there are some agreements that you will enter into with somebody that might not have those elements that a proper contract should have. And that is why we are here now to teach you what is contract. So we are starting with law of contract. At the end of this lesson, students or you that you're watching me, you're supposed to know, one, the meaning of contract. Two, why are contracts binding? Because of course, if contract is not binding, then what is now the need for contract? Three, the classifications of contract. And we'll look at the classification of contract under these three headings: express and implied contract, simple and formal contract, then bilateral and unilateral contract. So let's start. What is contract? The meaning of contract. So I am a nobody in law for now. So I will be quoting authorities. Now, Professor Itse Sage, in his book, Nigerian Law of Contract. I have the book here. This is it. Nigerian Law of Contract, Itse Sage. A very good book for law of contract. I recommend. It did not pay me to advertise, so, but then I recommend. Yeah, it's a very good book. I bought it since my 200 level in law, and it has been helping me so much. So now, what is the meaning of contract? Itse Sage defined contract as that agreement which the law will enforce. As the agreement which the law will enforce. Okay? So as the agreement which the law will enforce. This means that there are agreements that the law will not enforce. You understand? So, if you're watching this, it means you are probably going to enter 200 level, or you're in 200 level, or maybe you're just watching it for watching sake. But, and your 100 level, in your 100 level, you must have learned logic. When this is not this, A proposition, I proposition, and all that. But we are not going into logic. So when we say that contract is that agreement a law will enforce, it means that there are some agreements that law will not enforce. For example, we have the social agreements, your social and domestic agreements, where they will say, if you score first, I will buy for you bicycle. My father used to tell me that time that if I score first, I will buy bicycle for you. If you score first and your father did not buy bicycle for you, you cannot sue your father, because that is a domestic and social agreement. So, but now we're looking at meaning of contract. So let us not go into those ones so that we will not get confused. Now, meaning of contract, as I have said, Itse Sage defined contract as that agreement which the law will enforce, or which the law will recognize as affecting the legal duties and the rights of parties. So when a particular agreement affects your legal rights and duties, which means that you must have to do this particular thing. You don't have to, when you talk about rights, you are talking about, when you say your rights of choice, your freedom of choice and all that, it means you can choose to do or not to do. The law says you must do this, and it has affected your rights. So if you are expected to bring 2 trips of sand to this place by afternoon, it means that you don't have any other right to move around if you have not done that particular thing that you're supposed to do, unless maybe you have workers that will do it. But you see that contract has affected, or that agreement has affected your legal rights and duties. Now, be sure you pick these words carefully. Legal rights and duties. You cannot distinguish contracts from law, especially the ones the law will enforce. So that is why it's important to note all these things. Now, Nikki Toby, JCA, as he then was, Justice of the Supreme Court, Justice of the Court of Appeal, defined contract as an agreement between 2 or more parties that creates a reciprocal legal obligation a reciprocal legal obligation to do or not to do some things. So when they say it's an agreement that creates a reciprocal legal obligation, which means if that agreement does not create a kind of a notion of reciprocity, you do this, I do this, reciprocal. They say respect is a reciprocal, meaning if you respect, I respect. You understand? So if this agreement does not create some form of reciprocity, in Latin, it is called quid pro quo. This for that. Quid, where will I write this in? Quid pro quo. Don't know if you can see it. Quid pro quo. It means this for that. So, if a contract does not create that reciprocity, it is not a contract. It is probably a gratuitous arrangement. You understand? So, and when we go into contract consideration, you would understand all these things that I'm saying. So that is what Nigetobi said. Nigetobi said that contract is that agreement between two or more parties that creates a reciprocal legal obligation to do or not to do some particular things. So an arrangement that creates this reciprocity in order for you to do or not to do some particular things that are spelled out is called a contract, according to Nikitobi. Now, we've seen what contracts are. Contracts are generally agreement between two or more parties that the law will enforce. That so that when you do not do your own part of the bargain, I can now sue you to court, and the court will now give me, judgment. Now, for me to sue you to court, it means that that contract already is binding, because the law is enforcing it. So the contract is binding. So we'll now see, why are contracts binding? Why contracts are binding? When you say contracts, why are contracts binding? Can you not just trust me that I will bring in this thing? Why will you say the law will bind me to do this? The contracts are binding. Why? Because without law, of course, you did in your year one, you did the positive school of thought, you did the naturalist school of thought, you did all the school of jurisprudence, in an attempt to define law. But the ones that stands out for me, well, is the positive school of thought. When you say that law is this thing made by the superior to the inferior and is backed up by sanction. So without law, of course, you know that there are consequences. Without law, everywhere will be chaotic. Thomas Hobbes said that without law, life will be nasty, brutish, and short. And in order to ensure obedience, that is when you now start coming up with so many theories. Okay, punishment theory, okay, reward theory, and all that. So contracts are binding so that our commercial life will not be chaotic. Laws are expected to regulate many things that we are doing, because if there is no law, there will be anarchy. And of course, that's the general belief. If there is no law, there will be anarchy. And when your commercial life, or when the commercial, uh, you know, life of people, of citizens, are chaotic, nobody will, the country will not develop. Nobody will develop. Everybody will not be survival of the fittest. But now, contracts are there and contracts are binding, so that when you now see somebody and say, deliver me 2 trips of sand by this time, and the person did not do it, then you are able to turn to the courts, and the courts will now, show the bindingness of the contract and ensure that that person pays you damages, or that person does the specific performance. So we look at classification of contracts. Classifications of contract. Now, contracts can be classified anyhow you like, but we will look at contract classification based on these headings: the express and the implied contract, the simple and the formal contract, and the bilateral and unilateral contract. Now, express and implied contract is simple. Even from the name, you would have understood it. Express contract, the terms of the contract are expressly stated. They are clearly spelled out. You have written it, it is documented, and you can look at it and you can understand it and say, okay, this is what I am expected to do. So there is no room for speculations. There is no room for guessing. You already know that, okay, by Tuesday, I should supply you 50 trips of sand. That is express contract. The terms of the contract are expressly stated. Implied contract, on the other hand, is not expressly stated, but the courts will construe a contract based on the conduct of the parties. So we do contracts every day, every day, every day, but we don't know. If you stop on the road and you say, hey, Onaga, Keke, Marwa, I want to go to this place, and you enter the Keke, and you reach the place and you come down, you don't know that you've entered into a contract because you have to pay. The Keke person will carry you, you come down and you pay. That is a contract. But how will the court, of course, it is not clearly stated. There is no place where people signed an agreement that, okay, please, before I enter your keke, sign here so that, when you don't take me to the place I'm going to, I'll sue you and I'll present this as evidence. If there is no expressly stated document stating the terms of the contract, the court will now imply a contract from the conduct of the parties. Now, in the case of Brogin against Metropolitan Railway Company or something like that, the X, okay, I'll use X and Y. X wrote a letter to Y and say, okay, this is the terms I want us to follow in this contract. If you are interested or if you want to enter into this contract, please reply back with a letter to ensure so that we can now sign and everything. Y did not reply that letter, but went ahead to carry on to do things that were embedded in that letter. So when problems came up, they went to court, and Y is trying to say that, see, we did not sign any contract. The court said no, because you have acted based on the contract that, based on the letter, even though you did not sign, the court has implied that a contract existed between the two of them. Because, of course, they were trying to say that there was no contract between the two of them because they did not sign anything. You understand? So the courts usually imply that there is a contract through the conduct of the parties, and that is implied contract. So express contract, expressly stated, clearly spelled out. You cannot deny that there is no contract. The contract was there and you people signed it. Implied contract, the court will say, okay, let us look at what you people have been doing. Is your conduct, or have your conduct been such that would have implied that there is a contract between the two of you? Implied contract, by implication. I don't know if you understand it. Let me look for another example. So you want to somebody asks you, Alpha, I don't know why trip of sand is always in my head. Okay, let's use trip of sand. Get me trip of sand for 30,000. You did not reply that person. You did not say, okay, there is sand though. Okay, which one? Or okay, maybe you know the one that he wants. You did not really talk about it. You just carry the trip of sand and you come to that place. The other person will say, you did not reply me that you were bringing the trip of sand, so there is no contract between us. Because we say, if performance, did performance constitute, the contract? Because when you bring the trip of sand, of course, you had already told me that you needed the trip of sand, so I accepted by performance. When we get into offer and acceptance, we will do justice to most of these technicalities. And I accepted, and you're coming to tell me that we did not sign any agreement because we are supposed to have signed an agreement. You're trying to deny that a contract existed between us. Because we say it's a lie. There's a contract between you. Why? Because when you gave him the offer, he accepted by conduct. And the court will look at the conduct and say, we are implying that a contract has, by implication, a contract has existed between the two of you. That is implied contract and express contract. Now, simple and formal contract. Now, sorry, I will explain formal first. I don't know if you can see this board. I will explain formal first before I go into simple. Formal, simple. Sorry, I want to say it's simply defined. So, formal are just contracts under deed, under sale. Sorry. So, contracts under sale, which are also called deeds. Now, the reason this particular one is a categorization of its own is that in contracts under deed, in contracts under sale, not under deed, is deeds, but deeds are contracts under sale. Yeah. So when you talk about sale, you're talking about that red penchant that as most of you know what I'm talking about. Red penchant that would be, pasted on the document, to show sealing. Of course, it has been our jurisprudence has evolved. You do not need the red pen chant again, to prove that you have sealed it. The Evidence Act have said that if you sign signature and attestation is equals to sealing, but we are not entering into deeds. So we have so many deeds. We have deed of lease, deed of assignment, deed of many deeds. Of course, we have deed poll and deed indenture. That's like the two types of deed. But like I said, we're not going into deed. Just know, because you're in 200 level, I assume, and you're listening to this, formal contracts are contracts under seal. And the reason it is extremely important that it has its own category is that under formal contract, you do not really need consideration for the contract to be binding. Why? Because the seal, or because the seal is enough. So if you have a deed, you don't need consideration for it to be binding, because it is already binding as long as it is a deed. So if the deed is there, if you have prepared a deed, the deed is binding on you without the other person, furnishing consideration. When we go into consideration, you see that consideration is actually what makes a contract binding. Because if you don't furnish consideration, you do not have any right or local standing, this standi or standing, to sue when the contract. Of course, there is no contract, of course, if you have not really done the consideration. And that consideration is that notion of quid pro quo, which is the reciprocity that Toby talked about. Why simple contract is all other contracts that are not contracts under seal. So you see, when you're buying land and the contract is being, a deed of assignment is being prepared, you don't really need to say, the other person has not furnished consideration, the other person has not paid me, so it is not binding. No, as far as it is, the deed is ready, it is binding. So you cannot come, and when you are saying that this other person has not paid, that is why it is not binding. It is binding as long as the deed of assignment has been prepared, and as long as it has been sealed, signed, sealed, and delivered. So you cannot deny a contract merely because consideration has not been furnished, especially when you are talking about deed. But under simple contracts, other contracts, you must have to furnish consideration for it to be binding. So I've given you a difference. The difference between simple and formal contract is that contracts under seal need not, you do not need the furnishing of consideration for it to be binding. While simple contract, there must be consideration for it to be binding. Bilateral and unilateral contract. Now listen and listen attentively. In bilateral contracts, we are talking about exchange of promises. Exchange of promises. When we get into consideration, you would see that bilateral contract talks about executory consideration, and unilateral contract talks about executed consideration. So the type of consideration you would see in bilateral contract is executory consideration, where this person will promise, okay, this is what I want. This other person will give a promise, this is what I want, and you people will sign, and it is a contract between the two of you. So if I will give you 500 million for you to, to import so many tons of iron. I don't know how much 500 million worth of iron or maybe gold is. Now, that is executory, promise in exchange of promises. Executed, on the other hand, which is unilateral contract, is when a promise is made in exchange of performance. So when a performance is in exchange of the promise made in unilateral contract. I will give you an example. In unilateral contract, in Khalil and Kabbalic smoke ball, that is a very, very, very famous case that you must have to come across when you are doing your law of contract. In fact, if you don't come across this case in law of contract, you are joking. In fact, you've not started law of contract. Khalil and Kabbalic smoke ball, what happened? The Kabbalic smoke ball company, issued an advertisement in newspapers that if you use our smoke ball, and you don't, if you use our, they issued an advertisement and said, if you use our smoke ball and you catch influenza is like a sickness, you are entitled to £100. Now, sorry, the noise is much. So if you use our smoke ball and you still catch influenza, you will be entitled to £100. Khalil, a female lawyer, a lawyer, used that smoke ball and still caught influenza, and now wrote a letter say, give me my £100, which you said. They said it's a lie, oh, that that is a contract with the whole world. That it is not possible to make a contract with the whole world. But the court now stated that this is not a contract with the whole world, but an offer made to the whole world, which ripens into a contract when one person accepts the offer. And if you watch well, Khalil accepted the offer not by word of mouth or by information or by informing them. She accepted the offer by performance, and that is unilateral contract. Other examples you will see under unilateral contracts are reward examples. Hey, I'm looking for my dog. If you provide my dog, or you see my dog and you bring it for me, I'll give you £1,000. Then somebody now comes with your dog. That is acceptance by performance. You've made a promise and the person is coming by performance. That is unilateral contract. And that kind of consideration is executed consideration. Why the other one that is just promise, exchange of promise, is executory consideration. I don't know if you understand all these things. Now, because the time is already far spent, I will stop here today. Another time we will look at elements of contract. Elements of contract. But let me give oh sorry, I've already cleaned the law of contract. Let me give some form of introduction. Okay, I wouldn't know if you would see what I'm writing. Okay, so in elements of a valid contract, for a contract to be a valid contract, for a contract to be valid, for a contract to be a contract, a valid contract to be a valid contract, there must be presence of these elements. If any of these elements is not there, then that contract is not valid. Now, when you get to 300 level, you will look at offenses in your second semester, and you will see that in every offense, there are elements. And the work of the prosecution is to prove beyond reasonable doubt that the offender has committed an offense. And in order to prove that an offender has committed an offense, that prosecution is saddled with the responsibility of proving each and every element of that offense. If he misses one, it has the accused or the defendant, as we call it now, would go scot-free. And this is also the same thing that applies here. If there is no one, if 1, 2, 3, 4. Now this capacity, there has been some kind of arguments on whether capacity can form, a part of, the elements of a valid contract. But then it is the basis upon which contracts are made. Why? I believe so. Because if you don't have capacity to enter into a contract, then there is no need talking about whether or not it has offer acceptance, consideration, or intention to create legal obligation. What do I mean? So if you are maybe, let's say, a minor, and you are entering into a contract and okay, so offer acceptance, consideration, intention to create legal obligation, and capacity. So I don't know where this, because my mic stopped. I wouldn't know where it stopped, but thank God I have another one. Sorry. So I wouldn't know whether I was talking about yes, I was talking about capacity, but I don't know whether it was where it stopped. But capacity is the basis upon which offer acceptance, consideration, in fact, upon which contracts are based. Why? Because if you don't have capacity, then what are we doing? If you are a lunatic or if you are a minor, and the law says that minors, you cannot enter into a contract except it's a contract of necessaries, and you have to enter a contract with, through your next friend or through your guardian. If you do not enter a contract of necessaries, or if you do not enter a contract through your guardian, then all these ones would not hold water, because you don't have the requisite capacity to enter into a contract. Also, when we talk about lunatics, people that are lunatics, Of course, when we enter into that, we would see whether or not they can enter into a contract. But then that is why I said capacity is like the basis. So offer, acceptance, consideration, intention to create legal obligation. Our next class we will look at it in. We will look at this. This will be like this on this board until I treat these elements of contract, and I will take it one by one. These are loaded elements. This is not, it's not just offer is this, you know, acceptance is this. Offer has so many things inside. Acceptance, so many things inside. Consideration, oga patapata of them all. Intention to create legal obligations. We will now look at social and domestic agreement, commercial agreements, and all that. It is also loaded. Then we look at capacity. Capacity is also loaded. So thank you very much for tuning in. I'll see you next time. This is Prof TV. Please do well to like and subscribe. Peace.